Hello everyone, I am Scott Aubrey with Aubrey Law. We are an estate planning and probate law firm located in Needham, Massachusetts, and I'm very excited to be here with you today. And today I'm going to talk about how to get started with the estate planning process. What are the first steps you should do to get started? But before we start with today's subject, if you have any questions about what I talk about today or any questions about estate planning in general, you can go to estateplanmeeting.com, schedule a time to talk with me either in person or on the phone for free. Again, that's estateplanmeeting.com. So today's subject is how to get started in the estate planning process. Estate planning is one of those things where people seem to always want to procrastinate, and it takes people a long time to either get started or actually to get their estate plan finished. But today I'm going to provide you with some steps you can take to kind of get the process moving, get thinking about whether you need an estate plan and kind of how to get prepared if you want to go talk to an attorney about your estate plan. So the first thing you want to do is take an inventory of all your assets. So basically everything that you own inside and outside your house. It's anything over $100 is a good threshold. So make a list of all those assets. Everything you can think of, just jot everything down, whether you think it's something that it's important or not, just get it down on the list. The next step is to then kind of think about who you want to give those assets to when you die. If you're married, you're probably going to give it to your spouse, and if you have children, to your children. But if you're single, you may want to give it to relatives, to friends. You may have charities or churches that you want to leave those assets to. So you kind of want to get those things down. So the first step is to make an inventory of all your assets. Step 2 is to kind of think about where you want those assets to go. And then the third step is consider having a will. So I think a will is one of those basic estate planning documents that everybody over 18 should have. And basically what a will does is it will dictate who gets your assets, that list that you made, who gets those things that you put down on that piece of paper. Because if you don't have a will, what will happen is state law will dictate where those assets go to. If you're married, it'll go to your spouse. If you have children, it'll go to your spouse, and then to your children. But if not, they'll go to your other heirs, whether it be a sibling or a cousin, just depending on who's in your family and in your applicable state law. That will decide what you want to do. I think a lot of people don't always take this last step of drafting the will because they don't think it's necessary. They're like, oh, I don't have enough stuff. I don't really have any assets. It's more of a hassle. It's going to be too time consuming. I just don't want to go through with the process. But if you don't, what happens is, as I stated before, is that those decisions on where things go are made for you, and those are made by the state. And that may not be what you want to do. So if you want to have a choice in the matter and to say where your assets go, then you need to have a will to make sure that there's some directions left for your heirs to see how things would work out. So that's all I have for you today. If you have any questions about what I talk about today, please feel free to go to estateplanmeeting.com and schedule a time to talk with me for free. Either by phone or in person. Again, it's estateplanmeeting.com. If you like this video, please hit the like button. If you know someone could benefit from seeing this video, please please share that with them. And always, you can leave if you have a question or a comment, please leave them, and I'll be more than happy to answer them for you. Again, I am Scott Aubrey with Aubrey Law, and I will talk to you soon. Thank you.